Hello, everyone. This is Tom Fox. I'm the Compliance Evangelist, and I'd like to welcome you to This Week in FCPA for the week ending February 17, 2017. As always, I'm joined by my co-host, Jay Rosen. In today's episode, we take a look at former Magyar Telekom executive who settles a SEC FCPA civil enforcement action before trial, the Serious Fraud Office investigation into ABB regarding Unaoil. We talk about a new job for Jay Rosen. He is no longer Mr. Translations, and he will tell you about it. He previews his weekend report, and I go on an extended rant about the ISO 37001 certification process. The episode comes in at just around 30 minutes. This is Tom Fox. Thank you very much for listening to This Week in FCPA. Hello, everyone. This is Tom Fox, and welcome to This Week in FCPA for the week ending February 17th, 2017, the Worse Than Useless episode. As always, I am joined by my cohort, Jay Rosen, formerly Mr. Translations, who's going to tell us about his new moniker. Jay, welcome.
Thanks, Tom, and good to speak to everyone this week. Wanted to let you know that as of next Monday, I'm joining an organization called Affiliated Monitors. They're based in Boston, and they are one of the only truly independent companies that offers monitorships, whether they're from the debarment arena, FTC, FCC, or FCPA. So I'm still going to be working squarely within the ethics and compliance world. And now I might be a little bit dangerous enough to offer some insight into the world of corporate monitoring as well. So that is the news from my end.
Well, Jay, that's very exciting news, and certainly I look forward to hearing about the world of monitors and monitorship, and having you, although I have invested a lot of corporate branding in Mr. Translations, I guess that we will have to set that aside and brand you as Mr. Monitors going forward.
Sounds good to me.
All right. So, Jay, we had some interesting events and news items from this week in the FCPA and the greater global anti-corruption world. Let me start off with from across the pond, we had the Serious Fraud Office announcing an investigation into the Swiss engineering company ABB Limited. And it came about because of the ongoing investigation into Unaoil. Last July, the SFO had opened a criminal investigation into suspected bribery by Unaoil based upon the Huffington Post report of March 2016, and ABB was listed as one of about a dozen companies named in the report as beneficiaries of Unaoil's network in the Middle East. Last week, ABB self-reported some of its past dealings to both the SFO and the United States authorities in the form of the DOJ and the SEC. The SFO announced, or has previously announced rather, it had been approached by a number of sources who have information relevant to this investigation. Obviously, the Unaoil case brought a lot of headlines really across the globe. U.S. companies such as KBR and FMC Technologies were named. Other UK companies such as Petrofac were named. Unaoil was very loud in their protestations that they've done nothing wrong. So, but really the first investigation that we were notified of from the Serious Fraud Office. So in the context of the global fight against anti-corruption, I thought a pretty significant investigation. For those who don't remember, ABB is also a prior FCPA violator. So any action under the FCPA would be as a recidivist. So the Unaoil case continues to resonate. Then in the world of the FCPA, we had a former Magyar Telekom executive settled with the SEC before trial. A gentleman named Thomas Morve, agreed last week to a $60,000 penalty under the SEC. He had previously been sued by the SEC along with two other former Magyar execs, including the CEO, alleging they aided and abetted violations of the anti-bribery books and records and internal controls provision of the FCPA, knowingly circumvented internal controls, falsified books and records, and made false statements to the company's auditors. The executives used sham consultancy contracts with entities known or controlled by a Greek intermediary to pay up to $5.2 million, which they knew or should have known would be passed on to Macedonian officials in violation of the FCPA. Morval would have faced trial in May, but his settlement obviously ends that. What was interesting about this case, and I visited with Philip Urosky on my podcast, the FCPA Compliance Report, was the jurisdictional hook. And these individuals had not been in the United States when the actions occurred. When the alleged bribery and corruption occurred, there was no direct U.S. nexus in form of geography, no money passing through a U.S. bank, no emails going through a U.S. server. Nevertheless, the court accepted in personam jurisdiction, meaning personal jurisdiction, and that was really new and breaking. It was around the conspiracy aspect. So we still got two of the individuals, Mr. Straub and Mr. Balaw, who have cases pending. But with this settlement, it may be that the SEC is going to move to resolve these cases, and there'll be no final resolution of this really interesting jurisdictional question that the court has previously ruled on. So anything in either of those two recitations that you found of note?
Well, I think this, continues on with the desire for us to find individual accountability. So, again, it's somewhat a little bit problematic because it's, it's an agreement that they're not admitting or denying the charges. So we're still not at the point yet when we're getting, closer to individual guilty pleas. So I think that would be my only bit to quibble about. But, I think we will see more insight into that as we start moving forward into the Sessions regime. And, on the first article, I think it is pretty interesting. I think when the SFO gets their teeth into something, it's usually a pretty big matter. So I think it's significant that they're moving on ABB, and it'll be interesting to see how the rest of the global community follows suit.
You just touched really on the enforcement, individual accountability and enforcement of the FCPA. I did note that Trevor McFadden has been named as an assistant or associate attorney general by the new administration. He is a partner at Baker & McKenzie. He has specific FCPA experience, and he's written at least a few articles in the FCPA world. I'm trying to get a little bit more information on him from our friend Stephen Martin, who's a former partner at Baker, but hopefully we'll have a little bit more. But it would seem that with the appointment of Mr. McFadden, coupled with Jeff Sessions and his comments, that I think FCPA enforcement will continue, and certainly in the individual accountability arena, it will continue as well. These cases, if they do go to trial, might provide us some additional insight into that, Jay.
Yeah, definitely. So we've got a very interesting duality that Tom would like to share with you. And one part of it has to deal with the new ISO 37001 designation that a company can get. And at the same time, Tom wants to talk about this company. Do you say ENI or do you say ENI? What do you say, Tom? ENI. Who happens to be having a little bit of identity crisis with the new certification. So why don't you launch into it, Tom?
So last year, Jay, ISO, which is an international standards organization, announced implemented a standard for anti-bribery, anti-corruption programs. They had put the standard out for comment the year prior, which I guess was 2015. And the standard itself, I would say, is not controversial or is non-controversial. It articulated, I think, an 8-point program, things that everyone listening to this podcast would certainly be familiar and probably comfortable with. There are no trade secrets in compliance. There's a relatively straightforward series of actions you have to engage in to have a best practices compliance program, whether you call that the 10 hallmarks of an effective compliance program, the 6 principles of adequate procedures, the OECD 13 good principles, or the ISO 37001 standard. You know, the standard is acceptable, and it's certainly something that a company could follow, be a good guideline for you to follow if you didn't have access to any of the others, even if you couldn't read my book, which is designing an effective compliance program. So the fact that ISO introduced standards was, to my mind, fairly non-controversial. The FCPA professor called it a yawner. And I would have to agree with him on that point. A new set of standards for anti-corruption compliance programs, not hurtful, not really needed. Nevertheless, not anything that would offend anyone. However, ISO also certifies its standards. And this is where I do have a pretty big heartburn, Jay. And it is because when you certify something, you are taking a snapshot of where they are, where the program is at that point in time. And you are certifying that it meets certain criteria. Well, that meeting of certain criteria depends on a lot of different factors. And if you think back to Unaoil and Trace, the Trace certification of Unaoil, Unaoil bandied that across the globe as evidence of its good faith and of its compliance program. Well, it turned out that they had misrepresented to Trace. Trace got a lot of egg on its face for certifying Unaoil, but Unaoil misrepresented facts to Trace. Now, Trace didn't follow up on those facts to check them, and that's, on Trace. Nevertheless, the certification that Unaoil received turned out to be a very important part of Unaoil's compliance marketing efforts. But for the companies that relied on that, it was really worse than useless. And it was because it was damaging to them. And if you rely on a certification, you run into that same situation. And here with the ISO certification, if a company relies on the ISO certification, they could abrogate their entire obligations under a best practices compliance program. There's a reason the Department of Justice and the Securities and Exchange Commission have not laid down a requirement or an abject compliance defense, because they understand that if there is a requirement for a paper program, that is all corporations will do. And for companies that take a ISO 37001 certification as validation that a company has done in the past, and more importantly, will do compliance going forward, that is really worse than useless. You have to actually do compliance going forward. And I recognize that evidence in the past may be evidence of how things will forecast out in the future. And I would point you to 2 things. This year's Thanksgiving turkey, who's probably going to have a lot of good days in late October and early November, and have one very bad day in middle to late November, or putting it in 2017 Super Bowl 51 terms, with 8 minutes left in the game, Atlanta had a 99.7% chance of winning based upon what had happened the first 3 quarters and 7 minutes of the game. Conversely, the New England Patriots had a 0.03% chance of winning based upon the same information. And we both know what happened to Atlanta and what happened to New England. So certainly you have to base something on past behavior to predict future modeling, but that is not always going to be what comes out at the end. And most particularly in the anti-corruption, anti-bribery compliance world, you have to continually manage the relationships with third parties going forward. So any company that has a ISO 37001 certification, it really doesn't matter in terms of how you have to manage that relationship going forward. Now let's turn to the validity of that certification. And here we have Eni, the Italian national oil company, literally crowing that they received an ISO certification. The problem with that is that Eni's current CEO and past CEO are now under indictment for corruption. And although the corruption occurred some 5 years ago, you still have a sitting CEO accused by Italian authorities of engaging in bribery and corruption. Well, that is not tone at the top. That's actions from the top. That is actions from the very top. And if you have that at the top, what does that say about the tone throughout your organization? I understand Eni got that ISO certification, but that's just looking at the paper program. That really has, they obviously didn't talk to the CEO, and the board still has faith in the CEO because he's still the CEO. So what does that say about the organization? What does it say about the organization that you have an alleged paper program, but you have the CEO who's under indictment? What kind of message does that send? Do you think that the people who certified the ISO 37001 program for Eni looked at the tone at the top? You think they interviewed that CEO? You think that CEO said all of the right things about following the code of conduct? None of that happened. That's not the certification process. And so for Eni to bandy that certification, one, you have to question the value of that certification. But two, if J. Rosen Oilfield Service Company wants to do business with Eni now, and Eni is a joint venture partner, you are on actual notice that the company's CEO has been indicted for bribery. And the mere fact that they've got this certification doesn't mean you can trust anything they say or do. You have to manage that relationship from your own risk management perspective. And this certification really is going to, first of all, now that Eni has bandied this about, I think it may really end the value of the certification. But for anyone to think that that certification means you don't have to do your own due diligence into third parties and you don't have to do your own risk management going forward, it really belies what's going to happen out in the real world. And the Department of Justice and Securities and Exchange Commission were not part of the ISO development of their standards. I think the DOJ and SEC would be comfortable with those because, once again, the principles of a compliance program are fairly well known. But that's going to be of no defense to you when you go into the Department of Justice saying, well, you know, this company, our counterparty, had an ISO 37001 certification. How are we to know? Well, it's your responsibility to know. Now, let's turn to a company to getting an ISO certification. What's the value of that? We now know what it meant for Eni, but say ISO comes to you and once again, you're Jay Rosen, extraordinaire energy services company, former Mr. Monitorship, but you've decided that you want to get into the oil business and you're doing work internationally and you want to certify your compliance program. Well, great. What happens when you get that certification? Do you think senior management's going to continue to support you? They're going to say, well, gosh, Jay, you got a certified standard for ISO 37001. We don't need to put any more money into your compliance program. That's kind of point one. Point two, what happens if you don't get the certification? Are your investors going to say, why didn't you get the certification? Are they going to sue you because you haven't disclosed that in your financial statements and they say you should have? What about the SEC? Are you going to get a letter from the SEC or the DOJ and said, well, gosh, we've heard that you tried to get an ISO certification, but you didn't. Why was that? So really, there's no upside to getting that unless you're going to bandy that around to the rest of the market. But now that we know what it was for Eni to get it, I would suggest to you it's not going to be worth a whole lot. There's some other things that I could rant on, but others have ranted much better than I on them. For instance, Roy Snell, who says, Well, does the law department have to get certified? Does the IT department get certified? Does the internal audit department get certified? Does the HR department get certified? Does the CFO, financial department get certified? Do any of those departments get certified? I'm not talking about individual certifications by lawyers or any of those other professionals. Yes, I'm a lawyer and I have to get annual continuing legal education to maintain my bar license with the state of Texas. That is not a certification of the law department or any of the law departments that I worked in. You can get certified and win a J.D. Power Business Process Award, but that's not a certification of your compliance program. You can look at the Ethisphere, World's Most Ethical Company Awards, but Ethisphere is not going out selling those. Ethisphere is taking information in and awarding something. ISO is selling these certifications through the certification process. And I find that the certification process really does and can do a disservice going forward.
I think where this is all leading back to, and, people love to say that, Enron had the best code of conduct on paper, right?
Absolutely.
And I think that's where we're coming back to, Tom, that, with you always being about nuts and bolts and the doing of compliance, I think this example really underscores the fact that you have to do the compliance yourself, and no piece of paper, no governing body, no list of red flag companies at a very, surface level. None of that is going to be a prophylactic for you and your company falling into any trouble. So, it really is troubling, the point you make that ISO is out there, they're selling a service, and right now there seems to be a very minimal value to the service. And, that's especially underscored by what's happened here at ENI.
So I think this debate is going to continue. Christy Grant-Hart, our good friend, is much more pro ISO 37001, and she wrote about it in the FCPA blog. I think she and I are going to do at least one podcast on my podcast about it, and then the SCCE wants to facilitate some sort of either webinar or other debate that we might have. So the dialogue is definitely going to continue, but I think everybody who's listened to me understands where I come out on this and why I think it is really worse than useless. It's going to give a level of comfort that is, one, not warranted, and two, that the regulators are not going to put much credence in.
So, Tom, if anyone wanted to continue this discussion with you in person, can you let our listeners know where you're going to be next week?
Yes, next week I will be at the SCCE 2017 Utilities and Energy Conference in Washington, D.C. I will be there from Sunday to Tuesday. And although this topic is not on the formal agenda because it just came up this week, I'm sure there'll be lots of discussions around it.
Perfect. And I will also be out in D.C., so I look forward to seeing you and catching up with old friends and making new friends. We will have updated contact information for me in the show notes. And one of the things that I just wanted to say from a personal level, I wrote a blog last week that was kind of snapshot one of my journey within the ethics and compliance world. And, it talked about how I learned about FCPA. And one of the things that I really admire about the folks who are in this specific industry is that they are some of the most under-resourced departments in these global organizations. They are charged with the responsibility of keeping their company on the straight and narrow path and setting the ethical tones. And over the years, I've really come to respect these people. And one of the reasons why I decided to join up with Affiliated Monitors is this just really gives me more of an opportunity to help folks from an ethics and compliance perspective. That being said, if people still need advice on translations, I definitely know a good place to send them, and I can comment on that. But I really look forward in our future podcast, Tom, to really address the utility of a monitorship, how it can be looked at as a very either from a very pro side or a negative side. And also in the show notes, I think we're going to include an article that our colleague Mike Volkov wrote this week, which specifically addresses how our company looks at a monitorship and how they can either use it to their benefit or set up an adversarial position. So we'll put that out there. And then yesterday, Tom, we also posted our most recent Everything Compliance, correct?
That we did.
Yeah. So I think we are in that kind of netherworld. Pitchers and catchers are reporting. I'm still getting over my Patriots high, and I still don't believe we won that Super Bowl, so I still might have to watch it a few more times. But I as always, it's good to check in with you and with everyone out there on the internet. So for the week ending February 17th, this was the week in FCPA that was, and thanks so much for joining us.
Thank you, Jay.